dated 20th September 2024, containing documentary and evidentiary material that he intends to rely on together with his own statement to improve the credibility and the cogency of his apology. We do plead and pray that the short down and rates that Mr. Masengeli here is present be sworn in.
Just a minute. I have not, just a minute. I have not made a decision. You will allow me. You have made submissions and you're already asking your client to get to the witness box. Now, I don't want the back and forth because if you continue like this, we will not end these proceedings.
Yes.
I thought I'd given the Law Society an opportunity to speak.
Yes, my lord.
And what Mr. Miller and Mr. Owola were doing was a rejoinder, isn't it?
Correct, my lord.
So why don't you then allow me to make a decision?
Yes. Yes.
Isn't that the order of things?
That's it, my lord.
Yeah.
It's only that they introduced some new facts.
Which one?
The affidavit that was fact that we just learned about the affidavit.
It was not served.
Yes, it was served.
Was it served?
It was served. Though some,
When was it served?
For the purpose of this call, just go.
Yes. Let me just make a decision on this. Then
We served the
but you will understand that when in a proceedings of this nature, when one is summoned before the court, you not just rely on documents because the court will also want to observe the demeanor of that particular person.
Yes, my lord. Yes.
Yes.
And that's what my lord.
So it's not a question of filing documents. It's a question of complying with the order for the court to find out exactly what was happening from the person. The issue here is whether or not I should allow Mr. Masengeli to explain to the court why he has been deliberately defiant in disobeying the summons of this court.
But not enrich the record. So Mr. General has joined us.
Leading Mr. Harvey.
Yes.
Record.
Who?
He's come to lead Mr. Harvey.
Okay. The acting inspector. So who has joined us, Mr. Abbey? The Solicitor General. All right. Thank you. Welcome.
Comes immediately after the Attorney General.
Now this is the decision of the court. The issue before me, or before the court, is whether I should allow Mr. Masengeli, the contemner who is before the court, to explain why he deliberately disobeyed the orders of summons by the court, which led to his conviction and sentence. The Law Society of Kenya, led by the President Emeritus Nelson Havi, has urged me to deny Mr. Masengeli the opportunity. He has revealed that he has revealed to this court from the bar that the missing persons have now been released, and all I should do is to allow Mr. Masengeli to confirm that he has complied with the orders of the habeas corpus so that these proceedings can come to an end. Additionally, he has argued that Mr. Masengeli has filed 2 applications before the Court of Appeal, where he has appealed against a conviction and sentence, and one where he seeks an order of stay of these proceedings. Mr. Dan Manzo has argued or submitted that the court is now functus officio, since the jurisdiction of this court now rests with the Court of Appeal, has now been vested with the Court of Appeal following the filing of the 2 appeals. This position has been strongly opposed by counsels for the first respondent, Mr. Miller and Mr. Obola, who have argued that the court gave a coercive order which end compliance requirements. Further, the proceedings before the Court of Appeal are intended to deal with the conviction aspect and not the sentence. In making a decision on the issue before me, I must make a reference to the sentence of the order I made on the 13th of September 2024. In sentencing for contempt, there are normally 2 ways of punishing a contemner. Okay, 2 major ways. The court can choose to adopt a purely punitive approach, or can choose to use a coercive approach, in which it includes what is known as the purging conditions. The coercive approach gives the contemner the opportunity to save himself from punishment, the equivalent of purgatory in religious circles, so that if the contemner complies and fulfills the obligation required of him by the court can weigh and consider whether he has cleansed himself of the original sin. In my ruling on the 13th of September 2024, I had this in mind when I included condition number 4, which stated as follows: the court nevertheless considers it desirable to impose a coercive order as opposed to the punitive order. In this regard, Mr. Gilbert Masengeli can avoid serving the sentence if he complies with the direction to obey the court summons. I thus suspend the sentence for 7 days only. The acting Inspector General can redeem himself by availing himself before the court in person to answer to the issues he has been avoiding within 7 days. In default, the sentence shall automatically become effective. Having stated as much, and the contemner having availed himself before the court, before the lapse of the 7 days, I would be going against my own orders if I deny him audience as urged by the LSK. This is a court of justice and must act fairly at all times towards those that appear before it. Mr. Masengeli is entitled to be heard by virtue of this court order. The Court of Appeal has not taken away the jurisdiction of this court, for it has not issued any order being barring this court from hearing Mr. Masengeli. This court is not functus official either, as the sentence was not purely punitive, but coercive, laced with purge conditions that the court reserved to consider before the sentence becomes effective. I will thus allow Mr. Masengeli to take to the stand and redeem himself. You must be on the dock. Yes.
You are the on
Yes.
stemming from the natural right challenge that is
Yes.
the petitioners to serve the right to consent.
My lord, with your kind permission, this is a matter between the court and the condemnor, and it is strike law that the petitioners have no right to cross-examine.
Okay, let the order.
Sorry, that's not the premise. Because if it's just a minute, we have a right to handle. If he insists we walk out of here,
Yes.
we might as well walk out.
Okay, let me do this. Mr. Harvey, kindly listen. Let him explain. Immediately he has done that, I will seek submissions from you on whatever issue you want, then I will rule on it. But for now, let's just follow the order. Let's hear him.
My colleague has actually made
Yes.
advance.
Yes.
It is taking court by vote. We will reserve our right to cross-examine.
You will reserve the right to cross-examine, but let's first hear him. Then we can see whether it is necessary for you to cross-examine. Because you see, why do you make the decision to cross-examine before you have even heard what he says?
No, a prudent lawyer must
Just wait.
explain to the court what he intends to do.
Yeah, just wait until he does it, then we will consider.
My lord, may I seek your leave?
Yes,
May I seek your leave to leave the court?
very well.
Mr. Mutinda and Mr. Bita
It's okay.
will appear. Thank you so much.
Okay, Annette, swear the witness. Swear here.
So you repeat after me. I swear by the name of the Almighty God.
I swear by the name of Almighty God.
I swear by the name of the Almighty God
I swear by the name of Almighty God
that the evidence I shall give
that the evidence I shall give
touching the matter in question
touching the matter in question
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
So help me God.
So help me God.
Let's start with your full name.
Kindly tell the court your full name, please.
My name Gilbert Masengeli, Deputy Inspector General of Administration Police.
Can you tell the court the specific roles or role that you have been serving within the Inspectorate of Police?
My Lord, some of my duties and responsibilities is border security, ensuring that our borders are safe from incursion within and without for the safety of the Kenyan, my Lord.
Now, you have sworn an affidavit dated the 20th day of September 2024, which is here. Is that correct?
Yes, my lord.
Affidavit dated
20th of September 2024.
You've not been served with this affidavit.
It's been forwarded to Rebecca's form 5 minutes ago. Don't expect it in affidavit form.
Would it assist if I give you time to go through the affidavit? Because I can adjourn briefly so that you go through it, if that is what you want. Because basically what he's trying to say is he's going to rely on some of the information in the affidavit. Is it possible for me to allow you to go through that affidavit? I have a copy. I have a copy here, but I would, if you don't mind, I could ask my court assistant to have it photocopied by the court.
Hello, there is a return of service.
No, let's not get to that. We just want to do things in the right way. Yeah. Yeah, I just wanted to get a copy. Mr. Nelson Abbey, I want us to agree. Can I adjourn for 20 minutes so that you can, maybe 20 or 30 minutes if you wish?
I think 20, even 15 would be good.
Very well. So in So let's, from good order, let's adjourn for 20 minutes. We allow the petitioners to peruse the affidavit, and then we can proceed after that. I think it's important that we proceed when we are on the same wavelength. Yeah. Kindly let's adjourn and this one.
You need to be accounting for whatever that you do in your company. So these are serious functionality. So these has to be categorized. You must have costs related to that, like the wages, the salaries of the accountants, etc., research and development. What you're supposed to understand, ladies and gentlemen, in short, is the fact that functional classification, ladies and gentlemen, entails what? Functional classification entails us classifying our costs in accordance to the activities we engage in as an organization. So it's very important for us to appreciate that as an organization, which activities are we engaging in? Very important for us to appreciate that. So the various functions like manufacturing or production, research and development, finance, administration, selling, distribution, so various activities. I hope that is clear. Now we go to this other classification that we call behavioral classification according to cost behavior. How do this behave? Ladies and gentlemen, costs will be classified according to nature or behavior in relationship to change in levels of production, such as we have variable cost, fixed cost, semi-variable, and then we have the stepped fixed cost. The stepped fixed cost. Ladies and gentlemen, the most important thing that you're supposed to appreciate here in terms of behavioral classification is this, in terms of how they behave. Behavioral classification, how do they behave? You know, there are those costs that change as output changes. There are those costs in this case that are ever static, So in terms of behavioral classification, ladies and gentlemen, we have costs that are variable. We have costs that are permanently fixed. We have costs in this case here that are semi-variable. We have costs in this case here that move forward in form of steps, what we call the step fixed cost. Ladies and gentlemen, variable cost I would want you to appreciate from the word vary. These are those costs that change as the output changes. And normally they'll have a direct relationship. If this is output, then variable cost will behave like this. You can see as the output increases, variable costs are doing what? They are increasing. Variable costs are increasing. Great. So that is all about variable cost. Good examples of these variable costs will include things like raw material.